And it's very pleasing to see Alison back on, because she lost her Wi-Fi in the middle of that talk, but she's back with us. So she's going to talk on deemed authorization for organ donation, a new legal approach in Scotland. Now, Alison is well known to me. She is a member of our lay advisory board of the college. She's also Professor of Healthcare and Medical Law at Glasgow Caledonian University and is head of the department. She has been involved in a lot of government initiatives, both in Scotland and also at Westminster. And her CV is extremely long, but she's going to talk to us about the importance of this, the legal implications of this act. Thank you, Alison.
So thank you very much for the generous introduction, Richard. It's a real pleasure to be here. Some of the points that I'm going to make have been covered already by your esteemed guests tonight, but I don't think that does any harm to be able to go over them once again. So, as we've already heard, finally, the Act is here and it will come into effect this Friday, the 26th of March. And deemed consent in general for organ donation has long been discussed as a potential shortage, as a potential solution to the shortage of organs for transplantation, with several countries now, of course, already having implemented it. And as we noted already, as John said, Wales was the first of the UK jurisdictions to introduce the system in 2015. And I want to just be able to try and cover a few points. Time is very tight, but the first thing I'd like to have a look at is a little bit about the role of the family, and secondly, the role in government ministers in ensuring this widespread public awareness, and if we have time, some general ethical issues as well. So there has long been a shortage of organs for transplantation. This is not the case only in Scotland, but indeed globally. And even in Spain, which is generally considered to be the shining beacon of hope in organ procurement endeavour, hundreds of patients still die each year awaiting an essential transplant. Several solutions have been proposed, though perhaps most commonly espoused is what we're looking at now, the so-called deemed consent. Departing it does from the more traditional express consent model of organ donation, whereby not donating is the default. Deemed consent considers all those who die to be donors in the absence of a formally expressed wish to the contrary. It's a system that is now, as I say, being implemented across the world, and more countries consider the move each year. We've already talked a little bit about Wales coming into force with the legislation in December 2015, and there any deceased adult who is not accepted is deemed to consent to organ donation unless they had a decision relating to donation in force immediately before their death, or had appointed a person or persons to handle the issue of consent on their behalf. The Welsh Act also allows for a friend or relative of long standing of the deceased to object to donation, proceeding based on the views held by the deceased, provided a reasonable person would conclude the friend or relative knows the deceased's most recent view would have been against donation. The intention of the 2013 Act was to improve transplant statistics in Wales, which they have done. But it remains a moot, perhaps an ethical point too, that the extent to which deemed consent can be expected to improve donation and transplant statistics of its own, it remains a contentious one. Some evidence suggests an increase in consent donation and transplant rates following the introduction of deemed consent, and the success of Spain's organ donation is often attributed to based on deemed consent. So the legislation has a really important part to play. However, others question whether the legislation alone is responsible, suggesting that it is the role of transplant coordinators in hospitals to have proved the transplantation figures, and that the law itself plays a part, but only a contributory one. One question remains agreed by most, and indeed our speakers have alluded to it tonight, is the importance of good communication, sharing wishes, and keeping that communication door well and truly open. So back to Scotland then. So the Scottish Act, the 2019 Act, amends what was called the Human Tissue Scotland Act in 2006. This allows the donation of a deceased adult's organs for transplantation to proceed, where no objection has been raised. In Scotland, as already been said this evening, deemed consent will not apply to a person who had in force an opt-out declaration at the relevant time, was not ordinarily resident in Scotland for at least 12 months before the relevant time, or is incapable of understanding the nature and consequences of deemed consent. And I know we've picked that up already. The Act will apply to those over the age of 16. So young persons under the age of 16 will not be subject to deemed authorisation, and they will only be able to donate if they or someone on their behalf explicitly authorise it. One point as a lawyer and ethicist is the role of the family. This is something which has always been a bit of a mission in the law. Another individual, this legislation says, will be able to demonstrate objection on behalf of the deceased. However, there is no specification for the need for that individual to be in a qualifying relationship. Indeed, the Act itself simply states that a person may assume this role. No further detail is provided in the Act's notes on interpretation about who a person can be in relation to the deceased. It might be taken as meaning the nearest relative, as per the 2006 Human Tissue Act, and in fact it probably seems reasonable to assume that this is how it will play out in practice, as clinicians working in areas relevant to the procurement of transplantable organs are accustomed to and trained in this particular area. But it is important to recognise that the phrase actually used is a person and does not provide the more familiar language of nearest relative elsewhere. We've already spoken a little this evening about hard or soft out systems, and the central idea of deemed consent models is that express consent is not required. In the absence of explicitly recorded wish of the deceased, donation is legally authorised. However, there is a distinction between so-called hard opt-out and soft opt-out with systems of deemed consent. They usually exist on a spectrum of something between the two. Hard consent is deemed a pure deemed consent with little input from others, including family. Where such a law operates, all that can prevent an individual becoming an organ donor upon their death is a formally recorded objection made by them prior to their death. This would assume, of course, that the person's organs are fit for transplantation and they're not within an excluded group. Such systems are rare. They have been tried in jurisdictions such as Brazil, but they were overturned very quickly. Far more common are systems of soft deemed consent, which afford those qualifying relationships to the deceased an opportunity in some way to prevent donation proceeding. Such a system operates in Wales and Spain, which I noted earlier, is often highlighted as a prime example of organ donation done well and uses soft deemed consent. This means then that the role of those in qualifying relationships, such as the family to the deceased, are limited to demonstrating that the deceased themselves would have objected to donation. There does not exist a right to veto in Scotland based on those qualifying relationships' own views and preferences, but such a veto may be considered to normally operate in practice. The distinction between hard and soft deemed consent is really then about the role of the family, the qualifying relationships in the deceased, for the deceased. In England, where deemed consent applies, the guidance states that specialist nurses should explain the situation to those in qualifying relationships, giving them an opportunity to demonstrate that the deceased would not have wanted to be a donor. Of note, it is not possible to speak with those in qualifying relationships to the deceased, and if that is a case, the Code of Practice for England says the donation should not proceed if that opportunity has not happened. For me, Scotland appears to have adopted something of a middle ground between hard and soft. Clinicians in Scotland, as we've heard already tonight, have a duty to inquire when deemed consent becomes relevant in the context of a particular patient. That is to speak to those in qualifying relationships so far as it is reasonably practicable. The Act does not, unlike England, stipulate that donation should not proceed in the event that it is not reasonably practicable to speak to such persons. So in that sense, the Scottish model places less weight on the role of those in qualifying relationships and more on the very principle of deemed consent. For me, this seems good. This also seems to be within the requirements of the European Convention on Human Rights. Very important case for us lawyers in 2015 was a case of Alberti versus Latvia. And the court there was of the view that where the wishes of the deceased are not sufficiently clearly established, the state should make reasonable inquiries to ascertain from relatives whether the deceased would object. It is suggested that the reality is that there is significant space for manoeuvring in a considered and respectful way around the letter of the law. Families in reality probably will be consulted and will have a role, at the very least, in providing medical history. As the specialist nurses already have excellent communication skills, they are trained to navigate around the difficult issues on brainstem death, bodily integrity, etc. For me, the Scottish model is preferable because one of the biggest obstacles to organ donation has been the family veto. Let's move on, because the Scottish system deems consent and to me therefore has greater potential to increase organ donation rates, only with one proviso, that we need a high level of public awareness. Let me move on to this, and I'm just checking my time. I think I'm still okay for time. So for me, Scotland has done this well, and what it does, it has highlighted the role of the government ministers in ensuring public awareness. The 2013 Welsh Act placed a duty on Welsh ministers to promote transplantation by supporting a campaign once every 12 months to inform the public of how deemed consent operates in the absence of express consent. In Scotland, likewise, Scottish ministers are legally responsible for implementing means of public awareness, not only in the nature of deemed consent in terms of authorisation of transplantation, but also of pre-death procedures. Similarly to Wales, Scottish ministers must ensure continued promotion, not less than once each calendar year. For me, this is an excellent initiative, the continuing duty to raise awareness, which can be refined through new research, involves and provides us all with data. The duty on Scottish ministers to promote public awareness also demonstrates a willingness and to take responsibility for the change and its success in moving forward. It also helps us address some of the concerns that legislation alone is not the answer, but in a combined approach of public awareness and education. Very finally, I don't think I've got one more, oops, I thought I had one more slide there, but very finally, one concluding set of comments for me is around ethical issues. Widespread public awareness is recognised as essential to ethical defensibility of deemed consent as an approach to organ donation. It upholds the principle of autonomy, and it's widely held that autonomous choice requires the individual to be sufficiently informed with respect to the choice in question. So the idea that X will happen if you do not do Y, which is the underlying concept of deemed consent system. This is straightforward and can feasibly be communicated in a simple manner. Assuming efforts by the relevant parties to ensure awareness, it is reasonable to assume that a level of understanding that can be considered sufficient will be met, and those who object to being donors will take necessary steps to record this. So finally then, the current system that we have until Friday is based upon an altruistic approach. And very often the problem was not a lack of willingness, but a lack of incentive. It is human nature to procrastinate, which may have meant for some to passively accept a default position that involves less effort. But consideration should be given to the idea of dignity, fear of clinical neglect, family attitudes, religious belief, which may also affect an individual's decision. More generally, it may help families understand how their loved ones has made a decision, and having some knowledge of what was important to that person and helping them shape their decision may help remove some of the burden of decision making and pain from the families. A greater understanding about why individuals take the clinical decisions, not only in organ donation, but beyond that they do, will aid in the development of strategies and enhance our understanding going forward. Thank you very much indeed for listening, and I am very relieved that the technology has held out. Thank you.
And equally, I'm very pleased that you were able to give us your talk, Alison. I think you raised a number of issues there, and I think education and communication to me came right at the top. So I'm going to ask a question from our president. Should we do more for simulation-based communication skills training in this area? Would that be of benefit to perhaps trainee doctors in particular?
I was just about to say, obviously my background is not a clinical one, but I don't think we can ever underestimate the skills that our clinicians and specialist nurses have in this area. But communication is everything, I think, for the reasons that I mentioned, and getting buy-in and understanding from all the parties that are involved in this decision making.
Yeah, John, do you want to come in?
Yeah, I think when it comes to discussing these circumstances with families in intensive care, I think I think the specialist nurses who are involved in this, and as I said, specialist requesters who are an even more subspecialist group of these nurses, are really important. And there are data out there to show that if the specialist nurses are involved in approaching families, if specialist requesters are involved in approaching families, then the consent rate, the authorization rate is significantly higher. And I think that reflects just what Alison has said, the communication skills and the ability to talk to families who are incredibly distressed under these circumstances is really critical.
Yes, obviously the families are not used to being in that situation. It's new to them and it's very difficult. I was also interested, Alison, in the way you said that if the population is educated, then you can ethically justify deemed consent. And I thought that was very interesting and it hadn't occurred to me before. Do you want to comment further on that?
Well, I think so much now is about, we live in a rights-based environment, an environment where autonomy is held very, very highly. It is the principle by which in healthcare practice and in many areas of our life and times, the consent, the autonomy, the empowerment of the individual. So it would make sense to me to ensure the highest level of understanding, that people know what decisions they're making and why, allows us to be able to move to this model with the assurance that people are understanding what they are doing and why they're doing it.
I mean, it's rather like my question on capacity. If you don't know what can be done and you're not aware of it,
Right.
then you can't make a valid consent. So yeah, that's the way I would deem it. Now, I've got some other questions. Are there cultural religious views that we need to take into account when discussing this with the family? John, you've probably had practical experience of that. So we're thinking of people with certain religious backgrounds.
Yeah, it's a really important point, actually, and it is something that's really central to again, the education aspect of this, and also to the way families are approached. It's also there on the Organ Donation Scotland website when individuals go onto the website and they're there to express a wish around opting out or opting in. They can express a wish that their faith is considered. So it's really important. It's something that's really well recognised and
We've just lost you, John. I think that last sentence, we lost you.
So the faith considerations or the faith of the donor and the families are very much central to the discussions that would be had. I'm not sure if you heard my point, but actually, if you, on the organ donation website, when
yes, we got
individuals they can make sure that's considered.
Yeah, I think the organ donation sites, both the Scottish one and the UK in general one, are very good, and they're written in a very user-friendly language. Certainly, I had no difficulty, and I do a lot of writing for lay people, so I thought that was really helpful. Angela Campbell has asked, is there an upper age limit for donation?
No.
No, I didn't think that's right. And this is a good one. Perhaps both of you could answer. Perhaps Alison first. Is there a place for organ donation opt-in or opt-out in a patient's anticipatory care plan, i.e. they are knowing that they are seriously ill and that they actually can express their wishes? Perhaps Alison, would you like to?
Ooh,
do you know what we mean?
Yes, but I'm not sure if I'm the best person to answer that. John's looking quite thoughtful there. I'm not sure if there would be any additional considerations under those circumstances.
Yeah, I mean, I think there's certainly significant consideration given to organ donations being part of end-of-life care, but I guess it depends on where, which aspect of that anticipatory care planning process you would raise that. I think I think that's difficult. I suppose there are some moral and ethical aspects to that. Perhaps is someone making that sort of decision under those circumstances. Yeah, interesting question.
It's a very interesting question. Probably needs more thoughts there.
I'll give that some thought and take it back to the team. We'll have some consideration.
Yeah. I think that probably the final point, maybe one of the points on that, is that we would always do and the clinicians will do what they can to ensure that the patient's life takes paramount consideration. So their health, their treatment, the quality of that life is the most important thing to reassure them up to that time. But for many people, a conversation about what happens next, what happens to my organs. But I think John's right. It's when that conversation takes place. I think
one of appropriate.
From a practical point of view, actually, the circumstances under which patients are likely to become organ donors, the clinical circumstances are unlikely to be such that sort of conversation could take place with the patient. So I think that's probably one of the, I guess, just a very overriding practical aspect to that question.
No, you're absolutely right there. Yes. Lindsay Ross has asked, there specialist nurses or transplant coordinators available in remote and rural areas? And I would suspect they're rather thin and far between in certain areas such as Highlands.
They can go there, yep. But the remote and rural aspect of this is something that we are trying to address through the Scottish Donation Transplant Group, actually as part of the last organ donation plan. So that's something we are trying to address as much as possible, as is the case with very much of remote and rural healthcare.
Yes. No, I think, again, I know the answer to this one. This is Holly Doyne. If an individual has unequivocally said no, they don't want their organs to be transplanted, can the family override?
And authorised donation.
An authorised donation.
I think the only circumstance where that would be the case is, I would imagine, on the duty to inquire, the family had some evidence that the potential donor, although they had opted out, perhaps had subsequently expressed a wish to donate.
Yes, no, yes. That's. Sorry, Alison, go ahead.
Yes, no, I was absolutely would agree with that, and I think it just goes back to what I said earlier. It is not as much looking to the wishes of the qualifying persons, the family, the nearest relatives in themselves. It's what they know about the patient's story. Can they lead evidence to show what the patient would have wanted, or their next of kin would have wanted there? So I think unless they can bring something to the table that they had changed their mind, then no, they could not override.
Yeah. No, I think that's a key point, and it's the key point I got from your talk. It's actually what does the individual think, not necessarily what the relatives think. I've actually run out of all the questions, so that's very nice. So I'll wrap up. First of all, I'd like to thank John, Alison, and David for their contributions this evening. I think it's been a fascinating discussion from both the medical point of view and also the ethical and legal point of view. And thank you for your contributions. I thank the participants. We've had up to 250 people online this evening, which I think is a really large number, and it's more than we could have had in the college. For those that are listening, we'll be sending you an evaluation form, and we do look at them. Please fill them in, and then you'll receive your CPD certificate. I'd like to thank from the college, as well as our speakers, the college digital team, that's Roomvan Howard Hilditch and Jonna Fraser, and from the education department, Katie Ryan and Donna Johnston. Thank you for your help and support. Now, the next webinar is going to be on the 27th of April. It's back to a COVID subject, and this is COVID-19 international perspectives from the immunization point of view. We haven't fixed a time yet. It may well be during the day, because we want to be able to talk to our members and fellows in India, Pakistan, Bangladesh, and Southeast Asia. So we may well bring it forward because of the time difference. Otherwise, thank you for attending, and I wish you a very good night. Thank you, everybody.